This is Vicki Bowles, a partner in our information law team. Hello Vicki, you're talking to us today about privacy notices.
That's right.
So first of all, what is a privacy notice?
So a privacy notice is a document that organisations that process what's called personal data, information about individuals, have in order to tell people what information they have about them and what they're doing with it.
And is it really necessary to have a privacy notice?
It absolutely is necessary. It's actually a legal requirement. So the UK GDPR says that if you deal with information about people, you have to tell them certain information about what you have and how you're dealing with it. And there are various things that you actually legally have to tell people.
And is it a sort of fairly standard legal document where essentially the same privacy notice will do for different organisations or different types of organisation?
Not really. So there are elements of it that are standard. So for example, one of the things you have to tell people is the rights that they have, and everyone has the same rights, so that's standard. But actually the meat of the document is in this specific information that you collect and what you as an organisation are doing with it. And in my experience, even two organisations in the same sector, that can vary widely. So it's really not really a generic document.
And what are the risks if you don't have a privacy notice?
Well, the first risk is that you're then not compliant with your legal obligations, and that's obviously problematic. And actually that is one thing that the ICO takes into account if they're going to fine you. So you may have a complaint about something completely different, but if there are lots of other areas where you're not compliant, that increases the risk of a fine. The other reason it's useful to have one is that if you've got an individual who's making a complaint about your organisation, again, about anything, one of the first things they'll do is go to your privacy notice, and if it's not compliant, they'll use that against you. So it's something that you can easily just head off and then not have to deal with if it is right. The third reason that these are really useful, and the risks of not having one, is that there are certain rights that individuals have, as I mentioned before, and some of these are dependent upon the use to which you're putting information. So, for example, you might say that we are relying on your consent to process your personal data for the purposes of, say, promotional photographs and videos, which lots of organisations do. If you say that in your privacy notice, you might spend an awful lot of money doing a video like this, for example, and then you put it up on your website and one of the individuals in the video turns around and says, actually, I want to withdraw my consent. So legally, you then have to take that into account, and you might have to take that video down and reshoot it, which is obviously a huge cost. So it's really important, not just that you have the privacy notice, but actually that you get the information in it correct.
I see. So would it be possible then to have a privacy notice where you just say you can do everything, you do lots and lots and lots of things with the data, in the hope that you'll then be covered no matter what you subsequently actually do?
That is possible to an extent, and certainly when we talk to clients about drafting privacy notices, we do say to them, actually, there needs to be some element of flexibility in there so that you can, if you're doing one thing at the moment, but in the future you want to do something else, so that we can build that in. But actually, in terms of actually what you're doing with the data, the more specific you can be, usually the better that is.
Great. And does it matter that if people don't actually read the privacy notice? Because we all see at the bottom of the website says there's a link for privacy notice. We never click on the link. Does that matter, or is it still doing a job?
Actually, it doesn't matter if people don't read it. Your legal obligation is to tell them the information. Whether they take it on board, so whether they click on that link or read it, actually doesn't matter. And as you say, Doug, most of us don't click on notices. Even I don't click on them, and it's what I do for a living sometimes.
What a revelation.
Yeah, but actually, as I said before, as soon as an individual has a complaint, particularly if the complaint has some kind of data element to it, they'll go straight to your privacy notice, and then they'll become interested in what's in there and whether it's compliant.
Great, and then we'll be interested in it as well.
Yes, absolutely.
One more thing, you mentioned fines. How big are those fines? How big could they be?
Well, the maximum fine is £17.5 million or 4% of your annual worldwide turnover, whichever is greater. So the potential fines are actually huge.
That is huge. That is huge. Well worth getting a decent privacy notice. Okay, so someone looking at this and thinking either they don't have a privacy notice, or perhaps more likely they have one, but it might not be appropriate, it might not have been looked at for some time. What should they do?
Jump on the website, vwv.co.uk, and speak to one of our information law team. We've got a variety of products. Obviously, we work across a lot of sectors, so we'll talk to you. We have templates. Sometimes templates aren't appropriate and you need a bespoke version. Sometimes we can amend what you've already got, but we'd be more than happy to have a conversation with you about what you might need to do and the most cost-effective way of putting that in place.
Great. Vicki, thanks very much.